right, good morning, everyone. My name is Maria Flores. I'm the program manager with the U.S. Equal Employment Opportunity Commission, also known as the EEOC, and we are the key civil rights agency on the federal level responsible for enforcing federal laws that do not allow employment discrimination. If I could have next slide, please. Today's presentation is going to focus about the applicability of the laws that we enforce with respect to workers who may be experiencing domestic or dating violence, sexual assault, or stalking. Next, please. Again, the EEOC is a federal agency, and we're responsible for enforcing those federal laws that prohibit employment discrimination. Next. Our responsibility is to promote equal employment opportunity throughout the United States through a three-pronged approach. One way is education and outreach, which is my primary responsibility, to educate workers about their rights, to provide information to employer representatives so they can better understand the law, have best practices, and to promote EEO, and also just to get information to the general public. The bulk of what we do is our second prong, our compliance or administrative process, where individuals exercise their civil right for free discrimination, no attorney necessary. We step in as neutral fact finders, collect information, analyze it to determine whether or not there's evidence to support a violation. At any point during our administrative process, individuals may enter to voluntary forms of resolution. You may hear words like settlement, mediation, conciliation. Sometimes the worker can reach an agreement with the employer. The employer will provide some type of remedy, and the worker in exchange will sign off, no longer proceed with their complaint. If it doesn't work out, that's fine. We just proceed right back to investigation mode. If we find no violation, those cases are closed, but individuals can file their own right to sue against the employer in U.S. District Court. If we were to determine that the evidence shows that it's more likely than not that employment discrimination occurred, we are required to go through a conciliation process. We will work with the employer and the worker or the group of workers to determine how they were harmed by the employer's actions and what remedies the employer needs to provide to put the person or persons in the position as if the discrimination did not occur. If we can secure an agreement, great. Then the worker or workers are going to obtain some type of remedy for that employment discrimination. If we're not able to secure an agreement, then the EEOC most likely will need to close down that case, though the worker again retains their individual right to sue. Sometimes we get to the third prong where EEOC may actually file a lawsuit against that employer in U.S. District Court. Most of these cases do tend to settle out of court. Sometimes, though, we may actually proceed to trial. The EEOC would hope that it could convince a jury through evidence that discrimination did occur, and if the jury agrees and that verdict comes back as such, then the judge will order that remedy be provided. Next, please. We enforce a variety of anti-discrimination laws that go all the way back to the grandfather law, titled the Civil Rights Act of 1964. And as things change in the workplace, our laws need to change to protect individuals from employment discrimination. You see on the screen a number of different laws, again, going all the way back to 1964 to newer laws that were passed in 2009. Next, please. Without breaking down all of these laws make it clear, next page, please, that employers have responsibility to workers. Can I have the next slide, please? That employers have a responsibility to workers to provide them a workplace that's free of discrimination, retaliation, and harassment. And when employers' representatives are aware of these bad things happening, we need to put a stop to it, to investigate, and to make sure it doesn't happen again. In other words, we need to take prompt, effective, remedial action. Next, please. So what is employment discrimination? For us at the EEOC, with respect to those federal laws that we enforce, we're talking about different treatment, usually negative, because of certain personal characteristics specified in those laws that we enforce. Next slide, please. Next, please. There we go. So, in other words, it is illegal to treat anyone differently in any aspect of employment because of one's race, color, sex, religion, national origin, age, that's 40 and older, disability, genetic information, pregnancy, and now we've covered sex discrimination to also include LGBT, lesbian, gay, bisexual, and transgender individuals. Next slide, please. Additionally, all the laws that we enforce prohibit retaliation. Next, please. In other words, it is illegal to punish, penalize, deny someone an employment opportunity, benefit, because one, they've either opposed discrimination or they participated some way in our process, such as being a witness or filing a charge or providing testimony in the stand, or thirdly, that they have asserted their civil right to an accommodation due to their disability or due to their religion. Therefore, it would make it illegal for the employer then to strike out at the individual because they've exercised the civil right. We would construe that to be retaliation. Next, please. The employers that are covered under the federal laws enforced by the EEOC, generally speaking, need to have 15 or more employees. If it's under 15, state laws often kick in. And here in Wisconsin, the Wisconsin Rights Division enforces state laws that prohibit employment discrimination, and this can cover employers with as few as one employee. But for our discussion on the federal level and the federal anti-discrimination laws, we're talking again generally about 15 or more. This includes private employers, labor organizations or unions, as well as their apprenticeship and training committees, temp staffing agencies, as well as state and local governments, be it city, county, or state. Individuals with complaints against these governmental entities may bring a complaint to the EEOC on the federal level. Next, please. In terms of the workers who are protected from employment discrimination, also a wide variety. This includes the current employee and next employee. True, they're no longer working for the employer, but they filed a complaint within the required number of days with the EEOC. Other jurisdiction requirements are met. They're good to go for us to accept and investigate that. We also cover the temporary staffing agency worker, as well as the job applicant, and as well as non-U.S. citizens, regardless of their immigration status. Be they lawful permanent residents, refugees, asylees, even undocumented workers are protected from employment discrimination. Next, please. In terms of the issues that we see at EEOC, some of the more frequently filed ones include hire, fire, wages, promotion, demotion, discipline, harassment, anything affecting, again, terms, conditions, benefits, privileges of employment, whether it's job assignments, training, or leave. And again, we also cover failure to provide accommodation due to disability or to religion. Next, please. Now I'm going to focus in on two specific laws, Title VII of the Civil Rights Act and the ADA, the Americans with Disabilities Act, and how these laws may protect, again, those applicants or employees who may be experiencing, again, domestic violence, sexual assault, or stalking. Next, please. Again, that refresher, Title VII prohibits discrimination on the basis of race, color, sex, religion, and national origin. I want to emphasize sex discrimination is prohibited. And the Americans with Disabilities Act prohibits discrimination on the basis of disability. And again, both laws prohibit retaliation. Next, please. Again, these federal laws do not specifically state no illegal discrimination against these individuals experiencing domestic violence, sexual assault, or stalking. But there may be certain employment scenarios that individuals may be overlooked in terms of their protection under these federal laws. Next, please. So I'm going to provide some examples under Title VII and the ADA with respect to these situations and where federal law may kick in. Next, please. So let's talk about Title VII and disparate treatment because of sex. Disparate treatment meaning that intentional discrimination. So again, Title VII prohibits this different treatment based on sex, and this could include negative treatment because of sex-based stereotypes, or that individuals may not conform to gender norms. take our first example involving termination. An employer finds out that a female employee has been subjected to domestic violence, and the employer ends up terminating that female employee, stating that he fears the drama that battered women may bring to the workplace. All right, so playing into the stereotype about women being dramatic, and in this case, terminating this woman who has been subjected to domestic violence. Next, please. Our next example under Title VII involves failure to hire, and I think this is important to emphasize given EEOC's expanded definition of sex discrimination to include LGBT individuals. So this is a scenario. We have a gay male couple. We have here a male applicant who obtained a restraining order against their male domestic partner. We have a hiring manager who believes that only women can be true victims of domestic violence because men shouldn't be able to protect themselves, and therefore this hiring manager decides not to hire this male applicant. Next, please. Another example under Title VII, this one involving leave. So this particular example, an employer, allows a male employee to use unpaid leave for a court appearance in the criminal prosecution of an assault perpetrated on the male employee. However, a female employee in a similar situation who needs to provide testimony in the criminal prosecution of a domestic violence case she's experiencing is not granted unpaid leave. The employer feels that the assault by a stranger, in this case the male employee, is a real crime, whereas domestic violence is just a marital problem and women think everything is about domestic violence. So here we have two victims of some type of assault. In this case, the male employee is allowed to use unpaid leave for that court appearance because that is a real crime when it's an assault by a stranger, but the female employee is denied unpaid leave for her court appearance because, again, that belief that domestic violence is a marital problem. Let me switch this a little bit and talk about potentially how this could also factor into individuals who are gay. Let's say, for example, in a heterosexual relationship, to take off time to go to court to get a restraining order. So then we have this difference of treatment because of sex. Next, please. One of the ongoing issues that EEOC has seen involves sexual or sex-based harassment. In fact, the EEOC has a 6-point national strategic enforcement plan that talks about certain emphasis areas where we are concentrating on in terms of investigation, litigation, education, and outreach. And one of those emphasis areas is harassment. Title VII of the Civil Rights Act prohibits sexual or sex-based harassment. And harassment can violate Title VII if it's severe or frequent enough to create an overall intimidating hostile environment, or maybe if it results in tangible employment action. For example, an employer denying a benefit such as hire or promotion if the person does not conduct a sex act in exchange for that tangible benefit. Next, please. Sexual harassment, again, being the big type of form of harassment we see, in addition to things like race harassment. When we talk about sexual harassment, we're talking about unwelcome sexual advances, requests for sexual favors, and they may be a verbal, physical, or visual conduct, again, of a sexual nature that can create this hostile environment for a person of either gender. Next, please. Here are some examples involving physical acts of sexual harassment. Could include things like blocking someone's movement, preventing them from passing by, unwelcome touching, the accidental brushing up against someone, escalating to things like groping, exposing oneself to another person, rubbing, the massage you didn't ask for. Some of these actually escalate to the point of assaults, battery, and rape. Any physical interference with your normal work. EEOC, in terms of some of these more serious acts of sexual harassment, we have had situations where we need to step in as a civil rights agency with a temporary restraining order. So we come in where we see these serious acts of sexual harassment, kind of telling the employer, cease and desist what you're doing. But remember that EEOC is a civil rights agency. So I want to emphasize that when some of these acts become criminal in nature, it's important that that victim reaches out to their law enforcement authorities if necessary to file a complaint. Although EEOC in some of these serious sexual harassment cases that may involve sexual harassment or rape, often we do work with local or state authorities. But again, if these serious things are working, they're of a criminal nature, it's important to contact a law enforcement agency. Next, please. Nevertheless, when it comes to workplace harassment, employers have a responsibility to take immediate corrective preventive measures. So again, employers, when they are aware that harassment is going on, either because of complaints, formal or informal, or because the representatives have seen or are aware that this is occurring, put a stop to it, investigate, make sure it doesn't happen again. Additionally, to monitor the complaints to make sure that no retaliation is occurring. Next, please. So under Title VII, here's an example involving stalking. A female employee is uncomfortable because a male coworker sits too close to meetings and has made suggestive remarks of a sexual nature. The male coworker waits for her in the dark outside the women's bathroom and also waits for her in the parking lot outside of work. On the work premises, he blocks her passage in the hallways in a threatening manner. He also has begun to telephone her repeatedly after work hours, sends her personal emails, and has even showed up outside her apartment building at night. Next, please. The female employee reports these incidents to management and complains that she feels unsafe and that she's afraid of working near this male coworker. Now, management does take the next action to try to put a stop to this by transferring that male coworker to another part of the building. Unfortunately, this male coworker continues to subject the female employee to sexual advances and stalking. She notifies management, but no further action is taken. I want to emphasize here that even though some of this harassing conduct is occurring off premises, this does involve two workers. One of the most famous common scenarios that we give about this is the infamous Christmas party, where an employer may have a Christmas party off premises and one coworker sexually harasses another. This is a work environment, there are employees involved. Yes, it's not happening in the workplace, but the employer still has a duty to take action. Same type of similar situation here. We have this harassing conduct. Some of it is on company premises, other isn't, but again, it's against between two coworkers, and the employer has a responsibility to step in and take action. The employer did at one point take some appropriate action by transferring the male coworker to another part of the building away from the female coworker in response to her complaint. Now, if the company had involuntarily transferred the female employee, the one who's making the complaint of harassment, that involuntary transfer could be construed as retaliatory. She's not the one causing the problem. She made a complaint and brought it to the attention of the company. For them to involuntarily transfer her could be retaliation because she made that complaint. Now, unfortunately, in this case, the sexual advances in stalking continued. And remember, the employer needs to make sure to monitor and to take action to put a stop to it. At this point, the employer may need to take more severe action. Now, EEOC does not have a handy checklist of what disciplinary actions the employer needs to take with respect to certain types of harassing conduct. But obviously in this situation, what the employer has already done, transferring the male coworker, was not sufficient to stop the harassment, the stalking. It may be in the situation the employer may need to increase the level of its actions, potentially in this case, maybe actually terminating the male coworker. Next slide, please. Still talking about Title VII, let's talk about sexual advances and the intersection with domestic violence. I don't presume to be knowledgeable on domestic violence. I know a little bit like many individuals. And I would be interested to hear at the end of our conversation about some of our domestic violence advocates on the line about what they may see as individuals who are victims of domestic violence being singled out and re-traumatized in the workplace. So the example we have here, we have a female seasonal farm worker who has been subjected to domestic violence. She's now living in a shelter. Her supervisor is aware of this, sees her as vulnerable, makes sexual advances to her, and when she refuses, he terminates her. All right? So in this case, the employer representative, the supervisor, is aware that she already is a victim of domestic violence, takes advantage of that vulnerability, subjects her to sexual advances when she doesn't comply, and ends up terminating her. In an interesting case that we had also involving farm workers, a woman was a victim of domestic violence by her husband, who was a co-worker out at this particular agricultural field where she was working. Her supervisor was aware of it, and he had been subjecting this wife to numerous sexual advances. At one point, the supervisor reached out to her husband, who was the abuser in a domestic violence situation, her co-worker, to encourage the husband, her co-worker, to kill his wife. In fact, the husband did make an attempt to kill his wife. So this is an example within the farm worker realm, but certainly could be a situation, let's say, in a white-collar environment where, again, the employer's representatives may be aware of that female's vulnerability as a victim of domestic abuse and then take advantage of that in the workplace. Next slide, please. Title VII and retaliation. And again, Title VII prohibits retaliation for opposing discrimination, participating in our process, or asking again for accommodation due to disability or religious beliefs. Next, please. So here's a scenario involving retaliation. A female employee reports to Human Resources Department that she has been raped by a prominent company manager while out on a business trip. The company then engages in retaliatory action after receiving that complaint. The company managers reassign her to less favorable projects. They stop including her in important meetings, and they instruct co-workers to not speak with her. This would be an example of retaliation after she has made a complaint about what being raped by a company manager on a business trip. Next slide, please. We're going to switch gears now and talk about the Americans with Disabilities Act, the ADA, which prohibits different treatment or harassment based on an actual or perceived impairment. And some of these impairments or disabilities could result from domestic or dating violence, sexual assault, or stalking. Next, please. This is a failure to hire case. And as you're aware, a lot of times individuals can obtain information from other individuals via social media. So here an employer is using social media, going online, researching information about job applicants. He's researching about a female applicant, finds out that she had been a complaining witness in a rape prosecution, and subsequently received counseling for depression. The employer representative decides to not hire the female applicant based on the concern that she may require additional time off for continuing symptoms or further treatment of depression. So this would be a failure to hire case under the ADA. In other words, the employer is aware that she has an actual or a perceived disability, in this case depression, is concerned potentially that she may need accommodation, such as taking time off, and decides not to hire her because of this. This could be a violation of the Americans with Disabilities Act. Next slide, please. This is an example involving the ADA and harassment. Here we have a female employee who is badly burned in an attack by a former domestic partner. This has resulted in scarring because of skin grafts. She's off work for a while due to lengthy hospitalization, but once she returns to work, her co-workers begin to make negative, abusive comments about the facial scarring from those skin grafts, and management fails to take any action to stop the harassment. So in this case, we're having an individual who has been harassed because of an actual or perceived disability, in this case her facial appearance, the facial scarring for the skin grafts due to that acid burn. Next slide, please. Still continuing about the Americans with Disabilities Act, I'm going to provide a little bit more information now about reasonable accommodation. All right? The ADA requires employers, absent undue hardship, which I'll get into in a minute, to provide reasonable accommodation for a person who has requested the accommodation due to an actual disability or a record of a disability. I don't want you to get hung up on what we mean by a disability. We're talking about an impairment, physical or mental, which is substantially limited in a major life activity. What's a major life activity? It could be some of those adult daily living activities, the walking, sleeping, eating, breathing, personal hygiene, thinking, concentrating, interacting with other individuals, operations of bodily organs like kidney or liver, for example. It could be things like cancer. Yes, it may be in remission, but when it's active and it impacts major life activities, it could include that. It could also again be those psychiatric type disabilities, the depression, the anxiety, etc. And when we're looking at that impact of major life activities, it's as compared to most people in the general population. It's not an extremely high bar. We don't have to prove that it prevents or significantly or severely restricts the performance of the major life activity. Just comparing that individual and whatever that physical or mental impairment is, what's its impact on performing major life activity as compared to most people in the general population. I want to emphasize that because there was an amendment to the Americans with Disabilities Act which puts disability in a much broader compass and more people can come under that category of protection. So let's not overthink it. Next one, please. So again, employers are required under the ADA, unless they can show undue hardship, to provide reasonable accommodation. And what's reasonable accommodation? It's an adjustment, it's a modification in the workplace or the way that things are done to allow the individual to perform the main parts or essential parts of a position, or to enjoy the benefits or privileges offered to other employees. Now, the accommodations could include things like time off for treatment, modified work schedules, or reassignment to a vacant position. And in examples I talk about later, you'll see how this may factor in again to individuals who may be subjected to domestic dating violence, sexual assault, or stalking. Next slide, please. Now, again, the employers are required to provide that reasonable accommodation unless they can show undue hardship. What is undue hardship? It means that the employer can prove that to provide that accommodation is going to result in significant difficulty or expense based on the size of that employer, their operation, and their resources. All right? Now, this can vary from employer to employer. Obviously, a Fortune 500 company with a lot of staff and, frankly, more dollars may be able to provide more expensive accommodations, whereas a small business employer may not have all those resources, including monetary ones, to provide the reasonable accommodation. But often employers may be overthinking this. There was a study by the Job Accommodation Network, JAN, I believe this was in 2010, so maybe a little bit dated, and they surveyed employers who provided reasonable accommodations. In that survey, they found that about 79% of the employers provided accommodations that cost $500 or less. And about 31% of those accommodations cost zero. It was a very small percentage, maybe 2,000, I believe, 2%, that ended up costing in the thousands of dollars. So often an employer is in a position to provide the reasonable accommodation, and they may not be able to get out of the accommodation by showing undue hardship. Next slide, please. Now, if a person needs an accommodation due to that physical or mental disability, they can simply use plain English. No fancy words needed. They don't even have to say the words ADA or Americans with Disabilities Act or reasonable accommodation. The person merely is bringing up that they have some type of impairment, some type of difficulty in performing the work function, and the implication that they need some type of assistance. And these plain English requests for accommodations don't have to be in writing, though the employer may ask the person to put it in writing or to confirm the request for the accommodation. And very important here, the request for accommodation obviously can come from the employee or the job applicant, but it could also be an accommodation request made by a family member, a friend, a healthcare professional, or another representative, such as a job coach, for example. So again, plain English to say, hey, I need assistance because of my disability. Next slide, please. Also, once an employer is aware that someone needs an accommodation, the employer has a responsibility to engage in interactive, meaningful dialogue. All right, so again, this starts with the person with a disability indicating they have a need for accommodation. Then as part of this informal interactive process, there's discussion about the condition and limitations of that physical or mental impairment. The employer needs to hear out what suggestions the employee may have. The employer may have some alternatives. They may even seek out, let's say, some input from organizations that deal with individual disability to find out what options are out there. It's also very important for the employer to promptly follow up on that person's request for accommodation due to disability so they can provide that accommodation in a timely manner. The whole point is it's supposed to be meaningful dialogue. It's supposed to be interactive. It should be informal. The employer should not try to be legalistic and throw up a paper barrier. So again, once the person indicates, or their representative, that healthcare professional, family member, friend, etc., that employer then needs to engage in that meaningful, interactive conversation about that need for accommodation. Next slide, please. I'm going to briefly go off tangent here and talk about a different federal agency and a different law. The Family and Medical Leave Act, which is administered by the U.S. Department of Labor. All right, there's some information up there. I'm going to summarize it. I don't profess to be an expert, but I know just enough about the FMLA. So under the Family Medical Leave Act, certain public agencies and companies with 50 or more employees need to provide an employee with up to 12 weeks of unpaid leave each year, either intermittently or consecutively. And these employees are eligible for leave if they have worked for the employer for at least 12 months for at least 1,250 hours over the past 12 months. And this 12 weeks of unpaid leave, again, intermittent or consecutive, could be for a number of reasons, such as the birth or care of a child or an adopted child, or again, because that employee may be unable to work because of a serious health condition. Next slide, please. So now let's talk about the ADA and reasonable accommodation and how this may impact, again, individuals subjected to domestic violence, dating, sexual assault, or stalking. So here we have an employee who does not have any sick leave, and the employer is not covered under the Family Medical Leave Act. They ask for a schedule change or unpaid leave so that they may get treatment for depression and anxiety following a sexual assault by an intruder in her home. The employer does not grant the unpaid leave or the change in the schedule because it applies its leave and attendance policies the same way to all employees. Leave as an accommodation has been a particular issue that the EEOC has focused on. In fact, this month we have issued some updated technical assistance regarding leave as an accommodation. So often employers may have, let's say, a points policy involving attendance or a no-fault attendance policy, and they may not want to grant any leave at all. Well, in this case, the person does need the leave because they need treatment for their disability. What is their disability? Depression and anxiety. So even the employer may not provide unpaid leave for individuals. In this case, they may need to seriously consider this as an accommodation for this person who has been a victim of sexual assault. Next slide, please. Here's an example involving reassignment as an accommodation under the ADA. So here we have a female employee who was involved in a relationship with a male coworker. They have now ended the relationship. However, she's being stalked by the ex-boyfriend who continues to work in the same building. The employee ends up developing major depression, which her doctor feels is being exacerbated by continuing to work at that same building with that ex-boyfriend, again, who was a co-worker, also working for the same company. So, as an accommodation for her disability, in this case major depression, the female employee asks for reassignment to a vacant position. It's at a different location, she's qualified for it, and this different location is operated by the employer. The company denies the request, citing its no transfer policy. Under the Americans with Disabilities Act, a reassignment to a vacant position can be an accommodation for a person with a disability. The person is not required to compete for that vacant position. In other words, the employer should not post up the vacant position and accept applications from different people. If that employee needs to be in that vacant position as a reassignment because of the disability, they should place that person in that position as long as they're qualified and as long as they're able to do that newer position with or without municipal accommodation. Now, in this case, they need the vacant position reassignment because of their disability. In other words, to be away from the ex-boyfriend in that same building, again, because of the depression of being around this person. So by the employer citing its no transfer policy, conceivably this employer could find themselves in violation of the Americans with Disabilities Act. Next slide, please. I'm going to talk about medical information. The Americans with Disabilities Act has strict confidentiality provisions. Employers are prohibited from disclosing medical information to individuals who are not on a need-to-know basis. Additionally, any medical information cannot be found in an employee's regular personnel file. Medical information must be taken out of the personnel file and put in its own separate medical file with limited access. Who might be individuals who may have the right to that medical information? It could be example of advising a supervisor or manager, let's say where there's an accommodation issue. Let's say, for example, that I need a flexible work policy to take off work. Maybe I'm going to come in earlier during the workday, leave earlier at the end of the day to get treatment for my depression due to being the victim of a sexual assault. Probably a good idea that that supervisor is aware so that they'll discipline that person for the change in the schedule. It may also be individuals with government agencies who are doing investigations where they may need access to that medical information. An EEOC investigator, for example, conducting an investigation under the Americans with Disabilities Act may be entitled to that medical information. It may be a state investigator investigating a worker compensation claim. They may have access to that medical information. It could be an insurance carrier who may be doing an investigation. They may have access to that information. But it should never be the situation that an employee is, let's say, out in the lunchroom and they hear individuals talking about his or her medical status when she hasn't said anything about that. Next slide, please. So here's an example involving medical disclosure. Here we have a female employee who is being treated for PTSD, post-traumatic stress disorder, and this has resulted from incest. And she has requested a reasonable accommodation for that treatment. Her supervisor then tells co-workers about her medical condition. All right, so in this case, the employer has broken the medical confidentiality provisions of the ADA by disclosing this individual's medical information, in this case that she has suffered PTSD from incest, and mentions this condition to her co-workers, a violation of the Americans with Disabilities Act. Next slide, please. Let's talk about retaliation and interference. So again, like all of the other statutes enforced by the EEOC, the Americans with Disabilities Act prohibits retaliation. Remember what retaliation is: either opposing what they believe to be discrimination, participating in a process in some way, like a formal charge, being a witness, or again, asking for an accommodation, let's say due to disability. And it also prohibits the employer's representatives or someone from interfering with that employee's exercise of his or her rights to bring a complaint. Next slide, please. So this is an example involving involving the ADA and retaliation. So in that previous example, the employee tells the supervisor that she's going to complain to human resources about that supervisor disclosing her confidential medical information, i.e. that she suffers PTSD due to incest. And the supervisor threatens the female employee that if she complains about him having divulged that confidential medical information, he will deny her a pay raise that she is due to receive later that year. All right, so this would be an example of retaliation. He's threatening to withhold that pay raise if she proceeds in filing a retaliation complaint. Retaliation is also amongst those 6 emphasis areas of the EEOC's National Strategic Enforcement Plan, access to the legal process. And in fact, for about the past 4 years or so, retaliation has become the #1 category upon which individuals file charges with the EEOC. When we opened our doors in 1965 to about 4 years ago, race was the #1 protected category that people asserted in their charges of employment discrimination as the basis for the different treatment. Retaliation now has taken over that #1 slot, and we are very concerned about retaliation. Next slide, please. So what should you do if you believe that you are a victim of employment discrimination? Next slide, please. Take advantage of the employer's internal complaint process, if it exists. All right, so they have a process by which you can file a complaint. Take advantage of that complaint process. Why? Because you need to put the employer on notice that the discrimination had occurred. Now, there's other ways other than the internal complaint process, because sometimes, and I'm going to be frank here, my experience as an EEOC investigator in the past, is sometimes employees are aware that that internal complaint process doesn't work. So there may be other ways that they make complaints. They may make a complaint through a union grievance, for example. They may be a complaint to the supervisor. Maybe the person calls corporate headquarters. They may march themselves to human resources. Right? So it may not necessarily be a written complaint. But in some way, the person should bring this to the attention of management representatives. You need to put the employer on notice so that they are aware that this is occurring. And again, that triggers that responsibility for them to put a stop to and investigate and to make sure that it doesn't happen again. A lot of times individuals tell me, well, why should I even bother going to, let's say, human resources? As I tell individuals, yes, it may be true that a supervisor or manager may fumble the ball, so to speak, when they get a harassment complaint. They may not have received training in employment discrimination law. They may not be aware of how to handle the front end of an investigation or complaint. But by going to, let's say, the Human Resources Department, these are individuals who are trained in EEO, who are familiar with conducting workplace investigations. I've heard from human resources individuals in the past, and they have assured me that they want to hear about these complaints. They want first crack to take care of matters in-house. Otherwise, what happens then is that worker goes to where? Somewhere like the EEOC, triggering a federal investigation. Whatever that harassment is, make it clear that you don't want that harassment, that discrimination to occur, that you want it to stop. It's obviously advantageous to put that complaint in writing. Qualified here, no one at EEOC, not even our attorneys, offer legal advice. That being said, I will offer my professional opinion. It is advantageous to put your complaint in writing. If I were an individual with a complaint of discrimination or harassment or that I'm not getting my accommodation, I would put it in writing. I would make sure it gets to appropriate high-level representatives at my place of business. Maybe have someone date and timestamp receipt that they got that complaint. Maybe mail that complaint by certified mail so that I have a record of that employer having to receive that complaint. If you're doing it by email, again, you might want to maintain a copy of that, anything that can document that you had made this complaint. Again, you could always bring that complaint verbally, your supervisor, manager, human resource department. Once there's an investigation or individuals are following up on your complaint, participate in that process. Answer questions, provide information, be direct, be honest. And take it upon yourself to follow up with employers' representatives to make sure they're taking some type of action. Next slide, please. Next slide, please. Here we go. So if you're not able to get any satisfaction with your complaint of discrimination, harassment, retaliation, not getting your accommodation, Keep in mind that there are time limits, and you may need to reach out to EEOC sooner than expected. In order to file a charge of discrimination with the EEOC, it could be anywhere from 180 days to 300 days after the last date of discrimination to file a timely complaint with the EEOC. Generally speaking, here in Wisconsin, individuals have approximately 300 days from the last day of discrimination to make a complaint. So often individuals feel that they need to wait for the company to complete their entire internal investigation of, let's say, the harassment complaint, or maybe they made a complaint of harassment through the union grievance process and they feel it has to go through step 1, step 2, step 3, etc. Keep in mind that just because you wait for that process isn't going to hold the time limit for you to file a complaint with the EEOC. So I always tell individuals that maybe sooner is better to make a complaint with the EEOC. Next slide, please. So how do you contact the EEOC? You can call us toll-free at 1-800-669-4000. You can send us an email. Be sure to include your city and your state so they know where to direct that inquiry. And you can kind of start our process online at eeoc.gov. Next slide, please. So if you are a person who may be an HR professional or an employee representative, a supervisor, manager, or sometimes I hear from service providers or advocacy representatives, what can you do if you have questions about equal employment opportunity law and discrimination? Next slide, please. You can go online to check out our resources at eeoc.gov. We have a lot of information, including detailed guidance, but we've kind of wised up over the years, and a lot of times we may have fact sheets or information in question and answer formats. There are a lot of updates. You may learn about training opportunities, such as webinars or seminars. A lot of information on the EEOC website. But I tell individuals, if you're looking for information on the website, and you're not able to find it, don't waste more than 10 minutes on it. I can probably find it faster than you. Next slide, please. That brings me to the work about what I do as the program analyst or program manager for the Chicago district. So I represent the Chicago district, which is comprised of 3 offices. Our office in Chicago, one in Milwaukee where I'm physically based, one in Minneapolis. And between these 3 offices, our areas of jurisdiction are the states of Illinois, Wisconsin, Iowa, Minnesota, North Dakota, and South Dakota. It's my responsibility to coordinate and to conduct education, outreach, and training throughout those 6 states. A lot of the information that we provide to the public is no-cost outreach. Individuals are able to contact the EEOC if they want us to come and speak at a conference, a seminar. Maybe their organization is holding a monthly meeting. Let's say WCASA is holding some type of monthly meeting with the different regional groups. I belong to the Southeast Regional Group, for example. You can have us to come out and give a presentation, or you have a statewide conference, for example. Sometimes service providers may want us to come direct to their facility. You may have a support group, for example, for victims of domestic violence. I have spoken to those groups to provide information about employment discrimination law in their rights. I've also provided information to abusers, in this case to Latino males who are abusers in domestic violence situations, to talk about sexual harassment and abuse and how they need to abide by those laws. We also provide customized in-depth training, so sometimes employers may pay us to come out and provide in-depth training. But again, the vast majority of our educational presentations are no cost, and again, I'm available to also answer technical assistance questions. The supervisor, the manager, the human resource professional, even as service provider, advocacy rep, they may have questions, and that's my direct line that you see on your screen. Also, since we are taking advantage of this webinar with the EEOC, I understand that sometimes 1-800 numbers may not be the fastest way to get connected with the EEOC or any other type of government agency for that point. So if you may have an individual, a worker, a client, a consumer of your services who has a complaint, you're more than welcome to contact me directly at 414-297-3594 or via email. And I will be providing a PDF version of this PowerPoint and some additional information about EEOC. It will have my contact information. It will have my direct email address. So again, if You may have a customer, a client, a consumer that may be a victim of employment discrimination. You want to avoid that 1-800 number. You can either call me on behalf of that person, leave their contact information, or have that person call me direct. If I am in the office and available, I can pre-screen that person and get them started in that process. I do travel a lot, so if I'm not in the office or I'm not available, if you leave a voicemail message, at a minimum, I can transfer that in-house within the Milwaukee office for an investigator to follow up. So what I want to conclude with is by taking questions from our audience. Are there any questions?
We have two questions, Maria. This is Ian Henderson from Wakasa. The first question relates to slide 56 when you were talking about the failure to hire. How would someone prove that?
There's a lot that goes on that. I get that a lot from people who do not get hired, and they feel, well, how am I supposed to prove that no one hires me? So let me back up and emphasize something very important. When individuals come to make a complaint with the EEOC, they need only profess a belief that their protected category was the reason for that negative action. We don't expect them to come in with boxes of information or reams of printed emails and the like, or tape recordings, or pictures even, all right? So what happens in a hiring case, once someone files that charge of discrimination, that charge of discrimination is our key to demand information from the employer, and the employer is required to come across with information necessary for us to make a decision if a violation has occurred. So in a type of hiring case like this, we can gain access to, let's say, notes that were made during the hiring process. All right? So if I was looking at this case and a person is not hired because the employer has done some social media trolling on the websites to find out information about persons and found out that, let's say, this person was a complaining witness in a rape prosecution, there may be notes written on them. So we can have access to job application forms, to interview notes, to any notes made by selection officials. We also have the right to interview management representatives, in this case, the hiring officials, to gain that information. And you'd be surprised as to what information people say to us during an interview that they don't realize implicates them that they have engaged in employment discrimination. So that may be one way. That through the interview process of interviewing these witnesses, in this case the hiring officials, or looking at notes that they may have taken during the hiring process, we may uncover that this employer representative, one, had used social media to find out that this person was a complaining witness in a rape prosecution, and number two, maybe scribble something on the margins, don't hire, you're going to take off too much leave for mental illness. And that could be the smoking gun. Next question?
Yes, we have two more questions. Can you talk a little bit about the difference between the 180 and 300-day time limits? Like, what would be an example of a claim that has 180 versus a 300-day time limit?
All right. EEOC, again, we're the big dogs on the federal level. Of course, the federal laws that don't allow employment discrimination. We have state counterparts, state government agencies, enforcing state laws that don't allow employment discrimination. EEOC may have a contractual relationship with our state counterparts. All right, so what happens is, here in Wisconsin, you have the Wisconsin Equal Rights Division enforcing Wisconsin state law that does not allow employment discrimination. It has pretty much the same categories of protection that we do: race, color, sex, religion, disability, and the like. So an individual in Wisconsin with an employment discrimination complaint may have standing to file a complaint either with Wisconsin Equal Rights Division or with the EEOC on the federal level. All right? Now, if we have a contractual relationship with a state agency, then often that means that the person may have up to 300 days to make a complaint, and that's what the 300 days refers to. Our EEOC office in Milwaukee does have a contractual relationship with the Wisconsin Equal Rights Division. So that means that individuals have to have up to 300 days to make a complaint with the EEOC, 180 days with the state of Wisconsin. That's where the 180 days and 300 days comes in. Where we do not have a contractual relationship, then the individuals may only have 180 days to file a complaint with the EEOC. So I probably confused you even more, but it has nothing to do with the type of complaint, whether it's a harassment, an accommodation, a failure to give equal pay that has to deal with the 180 and 300 days. It has to deal with whether or not EEOC has a contractual relationship with our state counterpart. again, generally speaking, to make a complaint with us here in Milwaukee, it's approximately 300 days. And again, the sooner you get to us, the better. And don't worry who you reach out to first, all right? So if you come to us and it's something we don't cover, we may refer you to the state. Or if you contact the state and the state doesn't cover that protected category, they may refer you back to us. But you don't get two charges being investigated at the same time. We do share copies of complaints with each other. Whichever agency you go to first, that's the agency that tends to pick up the conviction and will investigate the case. I have all that information, but wanted to clarify that. Next question.
Okay, we have one more question. Could a victim of sexual harassment file a complaint with the EEOC if the person harassing her is, for example, a manager of a Section 8 apartment complex or public housing authority?
And that employee then has to work with that Section 8 manager?
Yeah, is it an employee? Let me see if I can get clarification on the question.
I think I know where you're coming
from. The person being harassed is a tenant.
Oh, a tenant. So there's no employment relationship.
Right.
Okay, that would be outside the EEOC's jurisdiction, and I'm not in a position to answer that question.
Okay, fair enough. Thanks, Maria.
Yeah, sorry about that. I did want to emphasize, though, that harassment by a non-employee, though, is a violation. So let's say, for example, someone works for an advocacy organization, one of the domestic violence advocacy organizations, and part of the program involves housing. And you have a case manager for a DV advocacy group who has to interact with a manager at an apartment building where it's Section 8 housing, right? And that Section 8 housing manager is sexually harassing the case manager who works at the domestic violence advocacy group. That would be illegal. So harassment by a non-employee is also prohibited.
Okay, thank you for that. Thank you.
There are no questions right now, but if you do have one, let me know in the chat or we can unmute your line.
Well, if there aren't any other questions, I'm going to leave you with a little piece of wisdom that my father, the professor, used to say, that there is no such thing as a stupid question, but people can stay stupid if we don't ask questions. So I want to encourage anyone with any type of questions regarding employment discrimination to reach out to the EEOC. You do not have to be an expert on the EEO. You do not have to have boxes of documentation. We want you to contact us as soon as you believe that something is not feeling quite right in the workplace. Go with your gut reaction, or what I said, put it through the sleep test, all right? Feel free to reach out to the EEOC, whether you're the worker, the advocacy rep, or even the employer representative, supervisor, the manager, the human resource person. We want to share information because we want to be proactive in eradicating employment discrimination. I want to thank you all for your time and attention. Goodbye.